Yes.
Your Lordship may make a mention for item 3 of hearing list. This may be taken up on this coming Thursday. I have taken the consent of the landed
I
PP.
think we have quite a few matters fixed
Yes.
for Thursday, isn't it?
Yes.
Is there urgency in the matter? We can list it for after the vacation.
My lord, this is a 2017 matter. That's why.
This is the state appeal, in fact,
Even then,
filed by the state.
isn't it? We will list it immediately after the vacations. Because we have quite a few matters fixed for Thursday.
After vacation, my lord, I'll have personal difficulties. That is why I want to take
So
it up
you
before
hand it
the
over to
vacation.
someone else? If I'm not mistaken, I think it's part 1 matters.
How about next week, Your Lordship?
Well, let's list it the next week.
Yes, but next week, my lord, Monday,
On
Tuesday.
Monday?
Tuesday, I'll not be available. I have one matter in the principal bench.
So what's the urgency in the matter?
Thursday.
It's a state appeal, only since
State appeal.
2017, that's all.
Next week, Thursday, I will be
Isn't
available.
it? No, Miss Linda, if you hand over the case to someone else, or we'll leave it like this, maybe on Friday.
This Friday.
We'll leave it for open for this week
Yes,
All right,
without
ma'am.
fixing a date.
my lord.
So on Thursday, if both of you are available, and we have time, we can do it. If not, on Friday.
Friday.
So we'll just leave it for
Yes,
the
my lord,
time
it's a
being.
short
Okay?
matter.
Depending upon the time.
Yes,
Okay.
Much obliged.
obliged. And item 5 of part 2, my lord, this is handled by Mr. Victor as amicus. And I've seen that he has submitted his letter of absence for this week. So if it can come up in the next week. This is also another state appeal.
Okay.
With respect to item number 13, my lord, part 2.
13.
Yes, my lord. My lord, this matter, I have not spoken to the additional PP yet, my lord. But if an attempt may be made tomorrow, my lord, to do this hearing.
My lord, they are hospitalized, so I don't think this week will be possible.
So we'll see, just leave it open for this week.
Fine, certainly, my
Okay, on
lord.
Friday, let's see what happens. Sure.
Oblige, my lord.
My lord, may I make a mention in item number 6, my lord?
6.
Yes, the matter may be taken up after a week, about a week, to file our objection for their IA.
There's an IA in item number. What?
Leroy Philly. On
Item
behalf,
number, this is what, in the hearing list or in the usual this thing?
usual,
Part 1 or part 2?
part 1, my lord.
Part?
Part 1. Item number
So
six.
you wait for your turn. Yes.
For motion, part 1, item number 1.
My lord, this writ petition is regarding the illegal suspension of Sialhok Village Council
Yes, yes.
by an order dated 1710.
Who's appearing for the state? So, yes. Mrs. Malsomi.
Yes, Lordship.
What is the stage?
This is For motion, my lord.
Oh, this is for motion.
Yes.
Notice can be issued,
Address
Lordship, at
writ
this
petition.
stage.
Okay, this is the same suspension of village, is it?
The
Or it's
other
slightly
ones are
different?
dissolution. This is suspension.
Okay. So what, which village?
Sealhawk Village Council, my lord.
White, what order?
1710. That
Where is
is in
that?
page number 70, my lord. 70, and English translation is in 71.
Read page 71.
71. The village council of Sealhawk under Khojol district has been accused of failing to disburse the full amount of government relief funds under the State Disaster Response Fund SDRF to eligible beneficiaries, leading to the filing of a formal complaint. Upon investigation, it was found that the full amount was only disbursed after the inquiry was initiated. This delay indicates that the government funds were neither fully or promptly distributed to the public. Therefore, the government has decided to reconsider the status of Sealhawk Village Council in accordance with Section 25(1) of the Village Council Act 2015, which states the Village Council may be suspended while the government hears the appeal. The Sealhawk Village Council is hereby suspended effective immediately from the issuance of this order until further notice. That is the
So the village council may be suspended while the government hears the appeal.
That is
So
in
is
Section
there
20.
some appeal?
No, there is no appeal. That translation is not
Correct? Is it?
not exactly correct.
Let's see
Here.
what is the correct.
Page number 37, my lord. May I kindly bring you to page number
37?
Yes, chapter 5 of the Lusai Hills District Council, Village Council Act. In subsection 1,
25?
yes.
Yeah.
the state government may by public notification order the dissolution of a village council if in its opinion the village council is too inefficient or is not able to carry on the village administration or is acting in the manner prejudicial to the interests of the state or for any other reasons considered sufficient for such dissolution and issue orders for holding a fresh election of the village council. Copies of all such orders shall be sent to the deputy commissioner
Okay,
of the
this is
district.
25, okay.
Yes.
Whatever. Now, this is a translation of page 70. So what does page 70 say? Is it's wrongly translated or what?
Not much wrong, but some
So just read.
error is there. Yes. Section 25(1) of the village council act, which states the village council
No,
may be
page 70.
Yes,
Is
70.
the,
Oh,
page
sorry.
70 is in the
Yes, yes.
vernacular language.
Yes. In the second para, chu wangin sarkar chuan Sealhawk village council te chungchang hi ngai tu anona duwa hemi chung hian village council kai hruaina 2015 section 25(1) in a soi tul big na omani chuan sarkar in hekna thu buai angai tu ala in village council chu achol lai lo tir theyang ati angin Sealhawk village council chu he order chu ani atang hian thule
So
om
the
ma chu
translation is very wrong, isn't it?
Yes.
It's the wrong translation.
Yes.
Nothing about appeal is mentioned in page 70.
Yes.
So what's wrong with this? Why have you filed the writ petition against this
This,
order? On what grounds?
This suspension originates without formal complaint. May I kindly bring you to my page number 40 of the petition. It is a spot verification report submitted to the respondent number 4, the director by DLAO. Yes. To the Director, Local Administration Department, Mizoram Aizawl, subject spot verification report in connection with Sealhawk Village Council regarding Madam, with reference to the subject cited above and pursuant to verbal instruction received from MLA 22 Tuichang ST Assembly Constituency on 25/2024, myself along with Pukelal Machuana, Field Inspector and Pu Augustine Lalung Muana, technical assistant went to Sealhawk on the said date, that is on 25/2024, to conduct hearing in regard to the complaints intimated by ZPM unit Sealhawk to the MLA, which pertains to an alleged misappropriation of disaster fund to be handed out to 21 families devastated by the occurrence of heavy rain and storm on 31/3/2024. There is no formal complaint submitted. The ZPMCL Hawk unit had submitted to the MLA, then the MLA had verbally instructed the executive officer, DLAO, to conduct spot verification. Then, before the verbal instruction was given on 25/2024, and the spot verification was done on the same date, 25/2024, without giving prior notice to the village council. Yes,
And in the meantime, the money has been disbursed?
yes,
to
the
the
money has
concerned?
been disbursed with the consent of the beneficiaries, because heavy rain and storm happened on 31/3/2024, and on the next day, social work was conducted by the village council. Then they have obtained the instruction of the permission, the consent of the beneficiaries. Then some amount was deducted for the expenditure of that social work and for
Okay, in
repairing
spite
of
of
those.
that, in spite of all the steps been taken, it's been suspended.
Yes,
So
yes.
that's why you've come to the court, isn't it?
Yes, yes.
Okay, we'll issue notice, let's see whether it's appropriate. Heard Mr. Lalpionte Latsongtho, learned counsel for the petitioner who has filed this instant writ petition for issuance of the appropriate writ or order to the respondents by stating that the respondents had issued an order dated 17/10/2024 suspending the village council Sialhok without there being any formal complaint against them and without any show cause notice being issued to them. With regards to the disbursement of money received under the State Disaster Response Fund, within brackets, SDRF, whereas the petitioners have already dispersed the said amount to the concerned persons eligible to receive the said fund. I think that's a gist.
Yes.
On hearing the submission made by the learned counsel for the petitioner, issue notice to this court find it fit to issue notice to the respondents. Ms. Linda L. Mrs. Malsomi, learned government advocate, accepts notice on behalf of the state respondents.
1 to 6.
1 to 6. Notice be issued to respondent number 7. Is it? Who's 7?
The MLA 22 Tuichang Assembly Constituency.
Okay. Now, why is he made the respondent?
Because he had given verbal instruction to the respondent number 54 inquiry. Because
Then
this,
we'll have to mention that before that, just read the first para. But on the verbal complaint made by respondent number, what's it, 7?
yes, this respondent number
But
7.
only on the verbal complaint made by respondent 7, okay?
My lord, verbal instruction.
Okay, verbal instruction made by respondent, sir. Okay, then issue notice to respondent number 7 through registered post with AD within 3 days, returnable by 3 weeks.
Yes.
Just after, now will 3 weeks be the vacation? Returnable by, let's make it 5 weeks then, list immediately after the ensuing vacation. Yes.
My lord, I have also made an interim prayer in my prayer portion to stop operation of that suspension order dated 17/10/2024 and not to hold any election with respect to Seal Village Council until final
Okay,
disposal
we'll
of.
make it a shorter date.
Yes.
Yes.
Let notice be received first, and then we can see you regarding the interim, isn't it? So list after 2 weeks on, when will it be?
January, maybe. Can we have a fixed date, my lord?
Okay, list after 2 weeks immediately after the reopening of the this court after the vacations.
Yes, my lord. Obliged, my lord.
Item 2.
May it please
Instead
your
of
lordship.
making it after 2 weeks, list immediately after. Cancel the 2 weeks. Yes.
My lord, this is a covered matter. We are employees of the respondents, my lord. Initially, we were appointed to the post of staff nurse on 30/5/2018, which was later regularized on 13/9/2021. Later on, we were again recruited to the post of tutor on 4/10/2023, my lord. So this is a matter praying for in increment as per the office memorandum dated 15/1/2010, which has been granted to several other nurses who have come before us, my lord. At the time of our appointment to the post of staff nurse, we had Bachelor of Science degree in nursing, which was not required for our post as staff nurse. So for that, we come for the 2 additional increments which had been granted to other staff nurses, my lord. But at the time of appointment of the tutor, our minimum requirement was BSc nursing. So we cannot pray for any increment for that post. However, for this post, we come to pray for the increment for the post we had held during our time as staff nurses. Similar order was passed by the Honorable Mr. Justice Nelson Silo on 1/11/2024 in WPC 111 of 2024, which was taken up for disposal at the motion stage itself, my lord. Similar nurses who had been appointed as staff nurse were later appointed as ward superintendent, came and prayed for the increment, for which the Honorable Justice issued direction to the respondents, my lord. So if similar orders may kindly be passed, my lord, in our favor.
We'll come back to your facts of the case. You
Yes,
were
my lord.
what?
We are now a tutor.
You were
under-
appointed, you were appointed
Initially
to the
appointed
staff-
as staff
staff
nurse.
nurse.
Yes, my
Okay,
lord.
staff nurse. When were you appointed?
30/5/2018.
Then what happened?
Later on, we were recruited to the post of tutor on 4/10/2023.
Okay.
So, my lord, yes.
4/10/2023
2023.
tutor.
Yes,
Then
my
what
lord.
happened?
So, for during the time as our posting as staff nurse, we are now
That is in between from
30/5/2018
to 4/10.
to 4/10/2023. So we are now applying, praying for increment, my
Why?
lord.
On what grounds?
If I may have your lordship. Attention at page number 23, annexion number 5. This is the office memorandum issued.
23. Okay.
Yes, my lord. So, according to this office memorandum, the several categories of staff nurses were allowed to be granted an additional increment as per their degrees, my lord. So, for our particular
case.
Yeah, your case.
Yes, 2 increments have to be
Where?
granted, which is at para 1B.
1B.
Yes.
Okay, what does it say? 1B?
2 increments to the nursing staff possessing the following qualifications. Number 1, BSc Honors, BSc, Post-Basic BSc, Post-Certificate BSc in Nursing. And at page number 24,
So now you're saying 1B, you are entitled to
2 increments. Yes, my lord.
Okay, because you're having what qualification?
I have a bachelor degree in nursing at the time of our appointment, my lord.
BSc, is
Yes,
it?
my lord.
So here it's BSc honors, okay, or BSc
Yes.
science.
Yes,
So
ma'am.
you're having BSc, is it?
Yes. This office memorandum particularly points towards nursing, my lord.
So here the first para,
Yes, my lord.
the nursing staff working in the central government hospitals under ministry of so and so. This addition in training so and so. This is Union of India, isn't it?
Yes, my lord.
So now this is, you're saying applicable in Mizoram also?
Yes, my lord. Several other judgments and order have been passed, my lord.
Okay, several, we look at those.
Yes, ma'am.
Anyways, 1 increment to the nursing staff holding the following post. That is certificate diploma is 1 increment
Yes, my lord.
if you have a diploma, and 2 increments to nursing staff. So you are saying that while you were the nursing staff, this is with effect from 2010, isn't it?
Yes, my lord.
And you were holding the post of nursing staff after the notification from 2018 to 23,
Yes, my lord.
2023. Okay, because of this OM.
Yes, my lord.
Then, what else?
So if I may have your attention to page number 24,
24.
paragraph number 4. The grant of the aforesaid increments is subject to the condition that the concerned nursing staff is not required to possess the qualification for which the increment is claimed as a condition of employment, and that they have not been allowed a higher initial pay on account of the said notification prior to or on or after 1/10/1986. So for our case, my lord, at the time of our appointment to the post of staff nurse, we already had bachelor degree in nursing, which was not required for our post.
Okay,
So,
where's that?
our bachelor degree the qualification certificate is at page number 25, annexion number 6, my lord.
Okay, so you have the bachelor's degree, but
Yes.
when you were appointed as staff nurse, you're saying this qualification was not required.
Yes, the
where's that?
lowest, my lord, it has not been written anywhere else, but it is known, it is known fact that the
Fact,
lowest,
how? So when you were going to be appointed as staff nurse, how were you appointed? Is there some recruitment rules?
yes, my lord,
So show me the recruitment rules.
it has
where
not
says
been
it.
annexed here with my lord.
Then you annex it so that we can know.
Several other staff nurses, my lord, has also been, who have been recruited as, along with us, have already received their increments as well, my lord, by this court's order, my lord.
Okay, where's an order of this court saying that to be appointed as staff nurse, you are
Yes.
not required to have a BSc degree,
Yes, annexure 7 and annexure
Okay.
number 8.
7 and 8.
With respect to our case, my lord, similar case is at page number 34, annexure number 8, WPC 111 of 2024.
Maybe in that case, the required documents were annexed or what?
No, my lord.
I have my doubts, because you're saying that to be appointed as staff nurse, you do not require the BSc degree,
Yes,
isn't it?
it's a GNM, my lord. The lowest degree was GNM.
So that, all those were the recruitment rules that says all that. It's just, anyway, but if maybe that point at the time of hearing was not challenged, admitted by the government advocate, maybe because of that, this order was passed. I don't know, because you've just given the judgment. So maybe at the time of hearing, it was admitted that BSc was not required when at the time of recruitment as staff nurse. Maybe. Anyways, so let's read the judgment. Page.
Page 35.
Have all the documents in place, isn't it? Page 35. Let's look at the facts, whether it's similar.
Yes, my lord. Heard Ms. Valentina Dinpui, learned counsel for the petitioners, and Ms. Lennon Louis, learned government advocate for the state respondents. Having regard to the nature of the case projected by the petitioners, and importantly the fact that it appears to be a covered case, the writ petition is taken up for disposal at the motion stage itself. Paragraph number 2. In the case of the petitioners, they were initially appointed as staff nurse in the Health and Family Welfare Department, Government of Mizoram, and subsequently appointed as ward superintendent in the Mizoram Medical College. The details of the appointment and the qualification of the petitioners, which is provided under paragraph 2 of the writ petition in the
So
form.
here all the details and qualification.
Yes, my lord.
Okay, then.
So the effective part is at page number 37, operative
No,
portion.
read on, 36 then.
My lord.
This is what is given.
Yes,
isn't
my
it?
lord. The details of the appointment and qualification of the petitioners, which is provided under paragraph number 2 of the writ petition in the form of the chart, may be abstracted here under table.
So they have done their homework here. Have you done your similar homework?
Yes, my lord. Page number 4, my lord.
Okay. Yes.
May I
Please
continue, my lord?
continue. Yes.
Yes, paragraph number 3. The petitioners contend that the qualification required to become staff nurse is GNM and for ward superintendent BSc Nursing. Since they both possess the qualification of BSc Nursing at the time of their initial recruitment to their respective posts, they were entitled to receive appropriate increment in terms of FR 2710 and OM dated 15/1/2010. According to the petitioners, similarly situated persons had approached this court through WPC 42 of 2024, Lalmingsang Silo and 52 others versus State of Mizoram and 3 others. And this court-wide order dated 8/8/2024 had disposed the petition with the direction to the respondent authorities to examine and verify the claim of the petitioners therein and to grant them increment as entitled to them within a period of 3 months from the date of receipt of a certified copy of this order. Paragraph 4. Page 37. Ms. Valentina Dinpui, learned counsel for the petitioners, submit that the instant petitioners are also similarly situated. A similar direction may be issued to the respondent authorities. Paragraph 5. Upon
Okay,
hearing,
so where's the FR 2710?
yes, my lord, it is at page number 22.
22.
Yes, my lord. Annexion number 4. Grant of additional increments qualification paid to the nursing staff.
Okay. Come back to 37.
Paragraph number 5. Upon hearing the learned counsels and upon the perusal of the materials available on record, it only appears that the instant case is a covered case, and accordingly the respondent authorities shall examine and claim the claim of the petitioners in the light of FR 2710 and the OM dated 15/1/2010. And in the event it is found that they are all having acquired degree or master degree before their appointment to Mizoram Medical College as staff nurse or ward superintendent, the benefit of the increment as laid down in the said provision be granted to them. The entire exercise be completed within a period of 3 months from the date of receipt of a certified copy of this order. Paragraph 6. With the above observation and direction, the writ petition stands disposed of. Paragraph 7. The petitioners shall also submit a copy of the writ petition along with the annexures with a certified copy of this order to the respondents.
Yes. So the government advocate, it appears to be a covered case. Isn't it? So can we dispose it off with passing similar order?
Yes, Your Lord.
Just to verify their documents and then accordingly as per the OM and the FR so and so it be disposed of, isn't it?
Yes,
Yes, so I'll pass the order later. A similar order will be passed.
Much obliged.
Yeah, allowed and disposed. Yes.
For admission, item number 3.
What's this matter about?
Your Lordship, on behalf of the state respondents, and on behalf of Miss Mary, if this matter may be taken up on the 6th of December, Your Lordship, this Friday.
What is the stage? You're supposed to file your, okay, you filed the counter. So it's
Pleadings
listed
have
for
been
admission
completed.
hearing.
Yes, my lord.
Okay, Miss Valentina, so-and-so, Lal Learned Counsel for the petitioner is present while mention is made on behalf of Mrs. Mary L. Kiante, Learned Government Advocate, for adjournment of the matter to 6th,
6th, Your Lordship,
2024.
Friday.
Okay. Accordingly, list on 6/12. Yes.
Much
You
obliged, Your
can
Lordship.
note your presence, the presence of Mr. So-and-so, Learned Counsel for your for respondent number. Number 3 is noted.
Item 4.
Your Lordship, in this matter, may I seek for further 2 weeks' time for filing of affidavit in opposition for the respondents, that is repunts. The reason being that, Your Lordship, the Parawa's comment has to be sent to the ministry first, because repunts is under the Ministry of Health and Family Welfare. And it was already prepared. However, it was sent to be routed through, thinking that it has to be routed through CGC. It was first sent to the CGC, but CGC said, since ministry is not involved, it was sent back to repunts. So again, we have to send to the ministry.
Yes. Mr.
Only 2 weeks.
Ramzawa, okay, we can grant them some more time.
Yes.
Mr. Sila Ramzawa, Learned Senior Counsel for the petitioner is present, along with Mr. Bilal Ramenga, Learned Standing Counsel for the respondents. The Learned Standing Counsel has prayed for a further 2 weeks' time to file their counter affidavit, which is not objected by the Learned Senior Counsel. In view of the above, list after 2 weeks.
Highly obliged.
For orders, item 5.
Your Lordship, I'm appearing on behalf of Mrs. Mary. If this matter may be taken up after vacations, Your Lordship.
Mrs. Mary, I think her child is in the hospital or something like
Yes.
that. A genuine problem.
Yes.
So, yes, Ms. Lal Nundui, Learned Government Advocate, submits that this matter has been taken up by Mrs. Mary L. Kiante, Learned Government Advocate, who is not able to appear due to some personal difficulties and has prayed for adjournment. In view of the above, list after the ensuing vacation. The presence of Mr. Bilal Ramenga, Learned Counsel for the appellant, is noted. Yes.
Much obliged, Your Lordship.
Item 6.
My lord, in this matter, I'm appearing on behalf of Mr. Cizoram Sana, counsel for respondent, my lord. May I seek 1 week further time to file our objection,
This is what
Well, look-
IA is about?
to file their additional documents, my lord.
What's the IA about?
So, my lord, in this IA, this is an IA filed under
Okay,
Order
it's to bring
41.
certain documents on
Correct.
record.
Correct. Yes. Certain documents on records. Now, this
Under
document,
order, you have filed it under order 41,
Rule 27, my
Rule
lord.
27. So what have you filed?
So, what we have filed, my lord, these are RTI replies, which were issued to our clients on 17/6/2016, my lord. This is at page number 10.
Okay, and it was not available?
So now what happened was, my lord, if your lordship will appreciate the records, from the records it is apparent that when our clients during the trial, my lord, he had done a handwritten note because he was not represented initially by a counsel. So he had done a handwritten note, written statement, my lord. His written statement was in handwriting. He did not know, my lord, that these things were supposed to be submitted at that time.
And so subsequently, when he provided these documents to his counsels, it was not submitted in court. So now we have found out these documents and we have submitted before this court, my lord. Now, the only reason why we have submitted this court, this judgment, this RTI replies, my lord, is because it supports the judgment of the lower court. So in the lower court, the judgment was decreed in our favor.
It was decreed in your favor.
Yes.
So you're not the appellant?
No, we are not we are the respondents, but we are the applicant.
Okay, applicant.
The only reason, my lord, is because it supports us. There was a gap in the story, my lord, in the entire record, and this thing supports that gap, my lord. That's the reason why we have submitted.
But they are the appellant.
They are the appellant.
Anyway, we'll have to look into the matter then. Is it?
Yes, my lord. And in this case,
Since
my lord,
they are the appellant and they are praying for adjournment, is it
and
that?
yes, no, in this kind of cases, my lord, there is one Supreme Court judgment. So, my lord, I think I should bring this to the notice of the court. Now, what it says, my lord, as per the Supreme Court's judgment, is that this kind of applications should not be decided independently of the main appeal. So it says, my lord, that it should.
So we'll hear the matter once they file their objection, isn't
Correct,
it? And then see whether it can be
Yes.
allowed. Yes. Mr. Joseph Lilson Himarently, learned counsel for the applicant, is present along with Miss
Delrod Philip.
Dalrod Pelly, appearing on behalf of her senior, Mr. C. Zoram Chana, learned counsel for the opposite party. The learned counsel for the opposite party has prayed for further time to file their written objection, which is not objected by the learned counsel for the applicant. In view of the above, list after the ensuing invocation.
Obliged, my lord.
Much obliged.
For hearing, part 2, item 1. Your Lordship, if I may seek your indulgence in mentioning that on item number 10 of part 2, that my senior had some personal difficulty.
Who is your senior?
Rosalind Elmar. Item number 10.
Okay, is your name here in the cause list?
No, ma'am. No, Your Lordship.
Okay, mention is made on behalf of Miss Rosalind Elmar, learned counsel for the appellant, for adjournment of the matter.
Much obliged.
Have you taken consent of the respondents?
Yes, ma'am. I have taken the consent from the opposite counsel.
And that the consent of the learned counsels for the respondent has been taken.
Much obliged,
View
Your
of the
Lordship.
above, list after the ensuing invocation. Yes.
Part 2, item 1.
My lord, before we take up this matter, my lord, there is one new development that I would like to bring to the attention of the court, my lord. So recently, my lord, that was in the month of November. I mean, November. What happened was our clients, my lord, received a summons from the district council court in relation to this particular case only. Now, what happened
But
is
if
that.
it's been disposed of,
It
fresh
was-
summons.
So what happened was they have filed one new application.
Oh.
And in continuation, they have basically filed one application which was in continuation of this application which we have appealed, which was disposed of. Anyway, my lord, that aside, what happened was, my lord, when we received the summons, we have been informed by the respondents that the respondent wants to get married, remarriage with another person. So she had submitted one undertaking saying that she does not want to continue with this case. Now, my humble submission, my lord,
That's the respondent.
that's the respondent, and we have a photocopy
No,
of.
so what about the counsel for the respondent? Have you been communicated regarding that? Any communication?
Not until this morning, my lord. I spoke to my learned friend, and I was informed that there was this undertaking, that there was this letter from the respondent stating that she wanted to
Yes.
withdraw from this case. But when I look into this letter that I have been given by my learned friend, it only states that, and I've spoken to my client as well, and what I've been told is that, my lord, she wanted, since she's getting remarried, she wanted to get a quick settlement regarding the divorce. But in terms of the alimony, she has no intention of letting go of the alimony, because, my lord, if we look into the documents and the records, it is clearly stated that the applicant herein has signed an agreement with the respondent before they got married, stating that he would pay an alimony of 5 lakhs in case a divorce takes place between the two of them. And now, my lord, what has
Now
happened?
she wants to get married, isn't it?
she wants to
so
get married.
can't they come to some settlement regarding the amount?
My lord,
no, my lord,
yes, she wants a settlement. I've just spoken to her. She wants a settlement, but in terms of the alimony, there's a child, there's a daughter between the two of them,
And the child is with
My lord, let me
the
just
child
point
is
out.
with the child is with the respondent, my lord. If I may just finish, the child is with the respondent, and now the respondent is without a job, has no earnings of her own. So the child is with her. The child is with her only, and she's getting remarried. So she wants to secure some sort of a financially. She wants to settle this financially for her daughter only,
financial
my lord.
security for the child.
Yes, security.
Is it?
Yes, my lord.
So, my lord, with respect to the permanent alimony that my learned friend is claiming, my lord, the judgment and order clearly says that that agreement is not valid. My lord, if your lordship
Okay.
will look at the
So if
paper-
if the judgment says the
And they have not
agreement
challenged.
is not valid, then why have you come on appeal?
No, so I'll explain, my lord. So now they have gone to this district council court. First of all, my lord, district council court does not have jurisdiction beyond 500 rupees. That is one thing we would like to point out, my lord. And if we go into the argument
District Council Court.
of Chakma Autonomous District, so they have jurisdiction up to 500 rupees, my lord. And now, my lord, if we are going to go into this deep argument, my lord, we will bring forth
Then the whole
arguments in
case-
this
the whole
respect.
case,
But my lord, with that aside, my lord, now what has happened is, in the order itself, they have come to and they had approached district council court trying to enforce this agreement, which they said was 5 lakhs. Now, the district council court in paragraph number 5 of its judgment has categorically stated that this agreement is not valid. But in
In
spite
spite of that,
the district council court said that under section 160, 126 of its act, it will give 2 lakhs 50 rupees as alimony,
yes, so
and
it's
which-
against the 2 lakhs 50 rupees that
which
you
we
have
have
come
come
on
to
appeal.
this court, correct. And we are saying that, my lord, the court simply did not have the jurisdiction to pass that kind of order. They could have approached a district court, a proper
Okay,
district
so
court.
it's on the grounds of jurisdiction.
Correct. But
appeal.
yes, but with that aside, and they have not challenged this order. That aside, my lord, they have now come up with this proposal. It's their client, my lord. We have the records. We cannot produce it in court because it's not from our client. It's from their client.
Yes.
My suggestion is let them take concrete instructions, my lord. It will be better for their client also.
See, find out, you talk to your client, okay?
Will do,
Try
madam.
and come to some settlement so that if she's planning to get married again, the marriage is not dragged along with a case regarding her ex-husband and some money issues.
My lord.
Okay, maybe you'll have to talk to her fiancé also to convince her.
My
I
lord,
mean,
we'll
it's
do that, my
better you
lord.
come to some settlement. This is
in
not
terms
just
of
a big
the-
issue, huh?
If I may, my lord, in terms of the alimony, there are a plethora of judgments of the Supreme Court and various high courts as well, stating that the husband, no matter the terms of the marriage,
But the
is
issue
responsible
here,
is
the
responsible
issue
for.
is not the alimony. It is the jurisdiction of
My
the
lord,
district
this
court.
jurisdiction issue was never raised by the applicant during the trial, nor even after the order was passed by the district court council. This applicant has filed one application with the district court council as well to reconsider the order passed by the district court council.
But isn't
But this
it
issue
for
was
the-
never raised by the
yes.
applicant.
But isn't it for the district court also to be aware of its jurisdiction?
True, my lord, true. In that matter, if
So you try to come to some settlement, okay?
I,
And
my lord,
concerning the appellant also, the money is not for so much for herself, it is for a child, which is most probably your child also. So in the best interest of the child, trying to have a broader outlook regarding the whole matter, and try and come to some settlement, get instructions, and it'll be good if you have settled the matter outside the court, and then you can
That would be good,
inform
my
this
lord.
court. It's not a big issue, isn't it? If you have a slightly broader outlook,
Yes.
okay, leave behind the past, whatever enmity, hatred.
I
settle the
doubt
matter.
any fruitful outcome would
No, my lord.
arise out of this, my lord,
My lord,
because
it's not a
the
settlement.
applicant herein has refused to pay this alimony because initially the amount of the alimony is 5 lakhs. and the district court council has given an one-time alimony of 2.5 lakhs, which is 50% of the alimony which has been.
So discuss the matter with your client.
Yes.
Okay,
My lord.
because the matter will be kept pending and dragging for a long time.
My lord.
When if you have a slightly broader outlook, it can be settled.
Yes.
Okay,
We'll do that, my lord.
And my lord, in
it's in the interest of both your clients that you
My lord.
explain how the matter stands, okay? And in the court, it is concerning the jurisdiction.
Yes. And my
So
lord,
let's see.
it's not so much a settlement also per se in the sense, my lord. What I'm trying to say is they have submitted an undertaking in the lower court, my lord.
So get instructions
Yes, we'll get
regarding the undertaking also, what it's about, isn't it? Yes. Heard Mr. Joseph L. Rentley, learned counsel for the appellant, along with Mr. Lalsan Himarsilo, learned counsel for the respondent. On hearing the submissions made by the learned counsels for both the parties, this court find it fit that due to the recent development regarding the information that the respondent could be getting married, remarried in the near future, the learned counsel for the respondent is to take necessary instructions from his client. Okay. In the meantime, considering the nature of the dispute, this court find it fit if the party could make an attempt to come to an amicable settlement. Accordingly, with the above observation, list after the ensuing implications.
Oblige, my lord.
Oblige, my lord.
Item 2.
Yes.
May it please your lordship. My lord, by filing the instant petition, the instant petitioner has challenged the order. This is at Annexure 11, page number 72. I will read the entire order, my lord, for better understanding. Pulal Thanmoy, a son of Shrang Kiava, officiating electrical worker, Electric Veng Lunglei, who was detained in police custody over 48 hours and who did not resume duty with effect from 01/06/1992, is hereby considered to resume duty as officiating electrical worker under Power and Electricity Department with immediate effect and until further orders. Regarding pay and allowances of Pulal Thanmoy, the period of his absence with effect from 01/06/1992 onwards will be counted as dies known for all purposes, that is, increment and leave. He will not be entitled to claim arrear pay and allowances during this period of absence, but will be entitled from the date of joining his duty. Pulal Thanmoya, officiating electrical worker, is posted in the office of Revenue Subdivision, Power and Electricity Department, Lunglei. So, my lord, what the instant petitioner has challenged is basically with regards to the provisions of paragraph number 2 regarding his area of pay and allowances, my lord. My lord, the case of the petitioner is that the petitioner was initially appointed as a lineman on master roll basis in the year 1993. However, my lord, the order of his appointment has not been annexed in the instant petition since that order copy has not been made available to the instant petitioner, my lord.
Then get that.
And however, my lord, prior to this appointment letter, he was White order dated 7/07/10/1988. He was appointed to the post of Jugali, and he was instructed to submit his joining report to the
where is
respondent number 7. This is at page annexure number 1, page number 28.
28.
Yes, page number 28, annexure number 1. His name of the petitioner is reflected at serial number 2.
It's again temporary.
Yes, my lord.
Yes. So
Is the arrangement, the officiating arrangement? The officiating arrangement is purely on temporary, and it states that his service can be terminated at any time. The true type copy is at page number 29, and my lord, the petitioner has submitted his joining report. That is at page number 30. annexure number 2. The English translation is at page number 31. And thereafter, now Jugali, as per the affidavit filed by the respondent, is an electrical worker. Jugali is an electrical worker. And if your lordship could kindly come to page number 32, annexure number 3, by this order, my lord, by this order, the instant petitioner was transferred and posted at Borpui Electric Section under Lunglei district only.
Okay.
His name is reflected at the bottom
Yes.
at serial number 11. Now, my lord, in the affidavit filed by the state respondents had disputed the appointment of the instant petitioner to this post, since he was appointed by the EE, Executive Engineering. However, my lord, perusal of the page number 34 would reflect that a copy of this appointment has been forwarded to the Chief Engineer, P&E. Also, at serial number 4, to the Divisional Accountant for information and necessary action for in order to make payment of his salary, my lord. Now, my lord, while he was working under the P&E department, the instant petitioner was arrested, and he was, my lord, he was charged under section 394 IPC and under section 14 of the Foreigners Act. If your lordship could kindly come to page number 36, this is at annexure 4. The reason why he was arrested was that an FIR was submitted by Sri Lalrid Moya, who was the SDO of P&E Department Lunglei, stating that one of the workers in his office, Smith Lalbese, a meter reader, was knocked unconscious, and that handful sum of amount of money.
Here there's a judgment, isn't it, of
Yes.
this court? So what does it say, the judgment?
This,
Acquitted or what? What happened?
my lord, he was initially convicted under section 394 and section 14 of the Foreigners Act.
Convicted. huh?
Yes, and he was sentenced to undergo RI for 6 months and for payment of rupees 200 rupees in default. And my lord, being aggrieved with the said judgment of conviction, he had preferred this instant criminal revision.
Criminal appeal.
Criminal revision, my lord.
Where's that?
This
Page?
is page number 36, annexure 4. The initial, I have stated in my
Where's the first judgment? You
My
should,
lord, I have stated in at paragraph 5 of my,
you don't have the copy of the judgment.
no, my lord. I have stated this at paragraph number 5 of my petition, my lord.
Copy not available.
Yes.
Why?
My lord, the conviction order was 15/11/1996. So, my lord, the instant petitioner has lost hold of the said judgment. However, my lord, the facts for which he was tried has been reflected in this page number 36 that I have annexure 4.
So as per the revision
So,
order of the
as
what does it say the court allows or sets aside or what?
it dismissed this annexure 4 dismissed the appeal, the revision that is filed by the instant petitioner. And being aggrieved, the petitioner was before this honorable court. And this honorable court uh, its judgment and order dated 31/3/1999. This is at Annexure 5. It had remanded back the case and directed the learned additional district magistrate to treat the revisional petition as a criminal appeal. And so this is at the operative portion is at page number 50.
Okay. So what does it say?
If I may read. The appellant might have, under erroneous belief, filed the revision petition and therefore the learned additional
No,
district.
all that is not required.
My lord,
Now, what
my
does the appellate court say? So it filed a criminal appeal. So as
Yes.
per the criminal appeal, what was the finding?
In the criminal appeal, this is at page number 52, annexure number 6. The instant petitioner was acquitted of the 394 IPC. However, the conviction under section 14 of the Foreigners Act was upheld.
Oh, convicted, huh?
Yes. And again being aggrieved with the order passed by the first appellate court, the instant petitioner was again before this honorable court. And if your lordship could come to page number 57, annexure 7, write this judgment and order dated 2/6/2011. This honorable court had set aside the order passed by the first appellate court and directed the learned magistrate to try the case de novo. And the case was tried. This is page number 61, annexure 8. By this judgment and order dated 11/10/2013, the instant petitioner was acquitted of all the charges.
Okay.
Operative portion is at page number 67.
So acquitted, huh? Then
Yes.
what happened? That's the criminal case is not so much an
Yes.
issue, huh? So finally he's acquitted. That's what
Yes.
you're trying
Yes,
to say,
my
huh?
lord.
Then
Now, during his trial, the petitioner was released on bail on January 1993. And when he was then instructed by the SDO, who had also filed the FIR, he was instructed to join his office and to submit his joining report to the instant respondent number 7. However, the respondent number 7 had refused and stated that the petitioner would be the joining of the petitioner to their office will be subject to the outcome of the criminal trial, not because he had availed bail. So he was refused from joining his office. Then after his
where is he refused?
my lord, this I have stated this at paragraph number 10, page number 11 of my
Okay,
petition.
nothing, no written document?
No, my lord.
Okay.
And at page number, at serial number 11, I have also stated that after his conviction, acquittal from the criminal proceedings, he again tried to, this is in the year 2013. First was when he availed bail in the year 1993. And when he was finally acquitted in 2013, he again tried to join his office. However, he was again refused by the instant respondent number 7. I have stated this at paragraph number
So
11.
respondent number 7, has he filed his counter?
Is the EE.
Has
The
he found-
respondents,
okay,
the respondents
case.
have
Okay.
adjoined-
Represented by
yes.
the government advocate.
Yes,
Then
they filed a joint affidavit. So, my lord, I was denied from joining my service, and only after the Law and Judicial Department, my lord, the respondent number 3 had issued this letter. This is at page number 9. Annexure number 9, I'm sorry, page number 69. Now, the instant petitioner had apparently submitted a representation to the state for reinstatement into his service. And the respondent number 4 had given this opinion to the respondent number 2 that, if I may read, my lord, the opinion.
Yes, okay.
The matter regarding application for permission to resume duty as Jugali under Power and Electricity Department submitted by Pulal Thanmoya, son of Frank Kiava, has been examined in the Law and Judicial Department and is hereby returned with the following advice. The Supreme Court in numerous judgments have observed that mere acquittal in criminal case is not a ground for reinstatement if determination is the outcome of departmental inquiry. In a case where inquiry has been held independently of the criminal proceedings, acquittal in criminal court is of no help. However, in this case, termination of Pulal Thanmoya was not an outcome of departmental proceedings. No suspension nor termination order has been issued till date. Hence, it would be in the interest of justice that the representation submitted by Pulal Thanmoya is considered. With respect to payment of arrear of full pay and allowances for the period from 1/6/1992 onwards, he may not be entitled to pay and allowances during the period of his absence from duty. With regard to his claim for regularization, he cannot claim it as a matter of right, and discretion in this respect lies with the appointing authority. Now, as per this, pursuant to the opinion given by the respondent number 4, the impugned order that I have challenged in the instant writ petition, my lord, page number 72, has been passed. This order has been passed. Now, I have also submitted a representation to the instant respondent number 2 and number 5. My representation is at page number 73. And the English version is from page number 75. However, since I was given no reply to my representation, I'm before this honorable court, my lord.
So what's your representation?
My lord, my representation basically says that I was,
No.
yes.
So what is your prayer in your representation?
My lord, my representation, if I may read from page number 76, the second last paragraph, that when I availed bail on January 1993, I went to the office to resume my duty. However, the executive engineer P. Power and Electricity Department, Lunglei Division, Lunglei did not permit me to attend office. That even though I was acquitted on merit by judgment and order dated 11/10/2013, the executive engineer P. Power and Electricity Department, Lunglei Division, Lunglei refused to let me attend office. However, pursuant to letter bearing number so and so, dated so and so, issued by the Law and Judicial Department, Government of Mizoram, addressed to.
Okay, so you joined duty in 2019.
Yes.
Now, you want your area from 01/06/1992 to
Till.
16/07/2019 before you attended.
Yes, madam.
That's your case?
Yes, my lord, that
Okay,
is basically
fine.
my case. Now,
And your main ground is that you had tried to join duty, but you were not allowed.
yes.
Okay.
And my lord, in this respect, my lord, the reason why I've stated that the FIR was submitted and why I've read out that the FIR was submitted by the SDO Pulari Noma. Now, in this regard, my lord, I would like to
Where's
submit.
the FIR?
FIR copy is not available in the record, my lord. However, it is reflected in the judgment passed by the first appellate court in the revision petition, my lord. This is at page number 36. Page number 36, Annex 4. Fourth line I will read from the first. The prosecution story of the case coming up for the revision in brief is that on 16 May 1992 at around 9:30 a.m. a written report was submitted by one Lalrin Moya, SDO PNE Department Lulei.
Okay.
Yes.
Oh.
Now, my lord, the case of the reason that I have been refused my area of pay and allowances, as per the affidavit filed by the state respondent, is that since I am a master role employee, I am not a government employee, and that I am not bound by the rules of CCS, CCA rules, my lord. That to the extent of rule number 3 may be correct, my lord. However, my lord, I have the government of Mizoram had issued various notifications, particularly in 2000. In the year 2000, this notification was issued for regularization of master role employees, which is regularization of master role employee scheme 2000. Now, according to this scheme, at number 3, application, according to this scheme shall apply to all master role employees in group C and D category under institutional finance and small savings department who are duly employed by means of engagement. And the regularization, my lord, this will come in effect after 5 years. After
So have
5
you
years
been
of
regularized?
no, my lord.
Then?
Till date, I have not been regularized.
So is that the issue here in this court? No.
No, my lord.
Oh, then,
And
then what do you have a case or not? Huh?
now, my lord, again in 2018, another notification for regularization of master role employee was issued. Now, the reason that I have stated, I have mentioned these notifications is that the only reason that I have not been able to enjoy the benefits of this notification is that I was refused to join my office, even though.
So is this the case for you not being regularized? Is that your case?
Yes, my lord.
So now your prayer here is that you should be regularized.
No, my lord.
Then?
Because the rules, now this 2018 had expanded the period of 7 years continuous service. Now, if the state government is going to count my service, then I have joined only in the year 2019.
Okay, so what is your prayer for regularization?
No, my lord, for payment of area
Then you
and
cannot,
allowances.
not on these grounds of.
Yes, my lord.
If you have not been regularized, you cannot, that's not your prayer here.
My lord, my lord.
Don't come to this.
The reason that I have stated is that if I were regularized, if I were allowed to join my service after my initial
So then,
acquittal.
make a fresh, this thing, you can withdraw this, file a fresh writ petition where you can pray for your regularization first, and if you are regularized, then you can pray for your area of pay. When you are not regularized, if, you see, because the regularization scheme also automatically, everyone doesn't get regularized.
Yes.
It depends on your seniority.
Yes.
Then,
But, my lord, that regularization, even that has been considered by the state government in the affidavit. And, my lord, the reason, even
so
though,
far, right
even
now
though,
you are not regularized, okay?
Yes.
So you're saying I should have been, could have been regularized, but you are not regularized.
yes,
It's as simple as that.
and the
And
only,
you have not prayed to be regularized in this writ petition, so we cannot say that you are regularized.
my lord, the law and judicial departments, my lord, they have stated that this payment of arrears, I cannot claim it as a matter of right, even regularization. However, my lord, if I may submit one citation.
Oh,
This is 2019-5 SCC 809. This is the case of Raj Narayan versus Union of India and others.
yes,
At paragraph number 6, my lord,
yes.
if I may read. Now, the first part the first part is going to seem like it's against me. However, my lord, I will read. Paragraph number 6. The decision of Ranchoji Chaturji Thakore was followed by this court in Union of India versus Jaipal Singh to refuse back wages to an employee who was initially convicted for an offense under Section 302 read with Section 34 IPC and later acquitted by the High Court in a criminal appeal. While refusing to grant relief to the petitioner here in this court held that subsequent acquittal would not entitle an employee to seek back wages. However, my lord, this is what I would like to stress. However, this court was of the opinion that if the prosecution is launched at the behest of the department and the employee is acquitted, different considerations may arise. Now, my lord, the criminal proceedings that was been
Where did you read from?
paragraph number 6.
6. Okay.
Yes.
Oh.
Paragraph number 6. Shall I read again, my lord?
Yes.
The decision of, my lord, has it?
Wait.
Page number 811, paragraph number 6.
Okay, I've got your point.
My lord. Yes. So, my lord, in the instant case, the criminal case that has been, that was initiated against me was done at the behest of my employer, the SDO, who had filed the FIR. And that I have been blatantly refused to join my service even after my acquittal from service. So, my lord, being the case, my lord, a different consideration may be made with regard to my prayers in the instant petition. And that, my lord, my petition for payment of arrear and also allowances, my lord, may be considered. That is my submission, my lord.
Okay, what is the nature of the job here? Back wages errors, suspension. So in this case, was this person a regular employee or a temporary?
My lord, he was a sorting assistant with the railway service.
So it's slightly different, isn't it? Anyways, yes.
That is my submission, my lord.
May I make my submission, Your Lordship? Your Lordship, in this regard, at first, I would like to submit that it's a matter the facts are settled as per he said, and first of all, he has no case because he was not regularized, and also the petitioner is not entitled to any arrears just simply because he was working for a long period of time. Whether he was made to join or not, that is not the issue. It was rather his appointment, whether he was a casual laborer or not, and whether he was regularized or
his
not.
appointment order? That the initial appointment order is not available, but anyway, he was on master basis.
Yes, Your
That's
Lordship.
undisputed, Okay.
And so, Your Lordship, the question arises whether he would be entitled to pay an allowance during the period of his absence. That is one question which has to be answered. And in order for him to be, entitled, he has to be a regular employee. And which is he is not, and he has not been regularized. It is a casual employment.
Which rules say that he has to be a regular employee?
Your Lordship, in that regard, I would like to submit a citation, Your Lordship.
Okay.
So, Your Lordship, I will just state the brief facts of this case. Union of India versus Vartak Label Union 2011 for SCC 2200. The case involved casual laborers working for the BRO, which is under the Ministry of Defense. And these workers had been employed on a daily wage basis, often for extended periods. And they were demanding regularization of their service and for payment of arrears for the time that they have worked. So, Your Lordship, in this regard, if Your Lordship may turn to page number 7, Your Lordship. I have made the pagination, Your Lordship. So, in page number 7, Your Lordship, in pan number 17, may I read, Your Lordship?
Yes.
We are of the opinion that the respondent union claim for regularization of its members merely because they have been working for BRO for a considerable period of time cannot be granted in light of several decisions of this court. wherein it has been consistently held that casual employment terminates when the same is discontinued, and merely because a temporary or casual worker has been engaged beyond the period of his employment, he would not be entitled to be absorbed in regular service uh, or made permanent if the original appointment was not in terms of process envisaged by the relevant rules. Now, Your Lordship, in this regard, he was appointed by the executive engineer. Whether the copy was given or not, that is just a internal matter, Your Lordship. The relevant part was the how he was appointed, and he was appointed by the executive engineer. So whether the copy was given to some officer or not is not relevant, Your Lordship, in this regard. And then, Your Lordship,
So this judgment which you read, just read,
yes, Your Lordship.
okay. Connect this to the instant case.
Yes, Your Lordship. And also, Your Lordship, the casual worker does not have an inherent right to arrears merely due to the long duration of employment. There is no clear statutory basis of claim of the petitioner, Your Lordship. So, in this regard, Your Lordship, again, if I may read the next paragraph, Your Lordship, paragraph number 18, Your Lordship. In Uma Devi, a constitution bench of this court had observed that it was then contended that the right of the employees thus appointed under Article 14 and 16 of the Constitution are violated. It is stated that the state has treated the employees unfairly by employing them on less than minimum wages and extracting work from them for a pretty long period in comparison with those directly recruited who are getting more wages or salary from doing similar work. The employees before us were engaged on daily wages in the department concerned on a wage that was made known to them. There is no case that the wage agreed upon was not being paid. Those who are working on daily wages formed a class by themselves. They cannot claim that they are discriminated as against those who have been regularly recruited on the basis of relevant rules. No right can be found on an employment on daily wages to claim that such employee should be treated on a par with a regularly recruited candidate and made permanent in employment. Even assuming that the principle could be invoked for claiming equal wages for equal work, there is no fundamental right in those who have been employed on daily wages or temporary or on a contractual basis to claim that they have a right to be absorbed in service. As has been held by this court, they cannot.
So the facts are slightly different, isn't it? This is a case where they are claiming their right to be absorbed.
Yes,
because
Your
they're
Lordship, and
working the
also
same
and also
factory.
areas for the past that they have worked. In this case, Your Lordship, the casual laborers were basically appointed on a yearly basis, and that kind of
Okay,
extended.
so yes, you're saying that during this period, that said period, he had not performed any work. Had
He
not
was on a
worked.
contractual basis, Your
So
Lordship. It was
therefore, he cannot be paid since he did not do any work.
Yes,
Isn't
Your
it
Lordship.
as simple as that, huh? Yes. Anything else?
And Your Lordship, in our submissions, Your Lordship.
Please read your submission.
Sorry, Your Lordship.
Yes.
Yes, Your Lordship. So, Your Lordship, please turn to page number 5 of the affidavit in opposition, pan number
By
6.
respondent's number.
This was a collective response, Your Lordship.
There are two counter affidavits filed. One is, okay, tell me the date. There are two counter affidavits that have been filed. One was filed on 7th June, the other on 9th April. So
Your
which
Lordship,
one are
June.
we?
June.
7th June.
Yes,
There
Your
was one which was already filed on 9th April. Two counter affidavits filed by the same respondents. One is from 2 to 8, one is from 1 to 8.
Your Lordship, I have the one which is of June, Your Lordship.
Okay, June.
Yes, Your Lordship. So, page number 5, Your Lordship. Pan number 6.
What is the difference? I'm just wondering. Anyways,
So, Your Lordship, pan number 6, it's may I read, Your Lordship?
yes.
That with regard to statements made in pan number 10 of the writ petition, I say that as can be seen from comments at pan number 2, the legal validity of his service is highly questionable, and additionally, from Office Order 237 of 1988, his officiating ad hoc appointment was purely temporary and can be terminated at any time without assigning any reason thereof. As such, it can be stated that he was having a criminal case while he was holding such a temporary post illegally with the government's leniency, Your Lordship. So he was not terminated as such. But actually, I mean, he did not join, and he was not obligated to, continue not being in office, Your Lordship. He could have actually stated his grievance there and then when he was not allowed, Your Lordship, to join, even if it was verbal. And now, Your Lordship, may I turn to page number 6, Your Lordship? Meanwhile, the government of Mizoram completely banned officiating appointment via Office Memorandum number 12015-194, dated 12/02/1999. Therefore, the department opined that there were reasonable grounds to reject the petitioner from joining a substantive post of electrical worker under PMD1 on officiating basis, which in fact was not his post as he was just officiating in that post. And Your Lordship, in order for him to be regularized, or even for his to pay his arrears at this point, he has to be coming under a statutory basis, have some statutory basis on this regard, Your Lordship, to claim any arrears, and which he does not have, Your Lordship, at this point, because he is not regularized. And merely because there's a gap, and he was not even, and Your Lordship, in this regard, may I please read page number 9, Your Lordship, the third para.
Read what is well prepared. Yes, 9.
Besides, after his case was settled by the court, he should have joined his post for duties, but he was absent from duties for more than 27 years. There is no evidence which show that the office prevented him from joining. As such, it can be concluded that he did not join his post and he did not perform his duties intentionally. Therefore, he is not entitled to pay and allowances during his absence period. Now, regarding absence period, Your Lordship, that citation which I have submitted before this court actually says that pay and benefits for casual workers are generally confined.
Wait. Come. Page where? What?
Your Lordship, page number 8, Your Lordship, of the judgment.
Para,
Pan number 21, Your Lordship.
Yes. Read.
Before parting with the case, we are constrained to observe that the conduct of the appellant in engaging casual workers for a period of less than 6 months and giving them artificial breaks so as to ensure that they do not become eligible for permanent status, as evidence from the additional affidavit dated 23/04/2010, does not behove the Union of India and its instrumentalities, which are supposed to be model employers. With anguish, we extract the relevant paragraph of the said affidavit. Relying upon the provision contained in paras 501 to 518 of the regulations, it was contended that the casual laborers are mustered on daily or monthly basis. If on monthly rates, the period of engagement shall be for a minimum period of 6 months. It is a fact that large number of casual workers have worked with Project Vartak for a number of years, but their period of engagement at no stage has existed more than 6 months at a time. Their services are terminated before completion of 6 months, and as per requirement, they are recruited afresh by publishing Part 2 order by mustering unit. Due to the fact that they have not been in continuous engagement for more than 6 months, they do not get the status of permanent employee, and accordingly, as per para 503 of the regulation referred to above, the casual personnel are not eligible for any other privilege for continued employment under the government. So, Your Lordship, first of all, there's a slight difference. I understand that, first of all, he was not terminated. And second of all, Your Lordship, for 27 years, he did not join this, his employment.
So what you read just now, I don't know the applicability of those para. Anyways, yes.
Your Lordship, this para is of relevance because it talks about continuous engagement. So let's say even if his term was not terminated, and assuming that he was still engaged, though he might not have been physically present in the office, it still cannot be counted as.
See, this is an observation regarding the engagement of master role employees just for 6 months, and then they're terminated, and then they're again employed for another 6 months.
Yes, Your
Isn't
Lordship.
it? So here the Apex Code does not approve of this. Okay? and says that a proper something should be done about this, where the employees have been employed for 30 to 40 years. So the Union of India would consider enacting an appropriate regulation or scheme. This is where the observation of the Apex Code that if this procedure should not be followed, and then the Union of India should take steps to enact an appropriate regulation or scheme for absorbing or regularization of those employees who have been engaged for about 30, 40 years, and the mode of engagement is just for 6 months and then again renewed 6 months. So I don't think this instant case is applicable in your case concerning that and your argument anyways. And we leave it at that.
Yes,
So your main submission is that she's a master role employee.
Yes, Your
Okay,
Lordship.
and because of that, he is not entitled to wages, area of wages, since he has not joined his service.
Yes,
Isn't?
Your Lordship.
I think that is the shortcut, a gist of what you have just submitted.
Yes, Your Lordship.
You have made you have submitted a comprehensive counter affidavit.
Yes, Your Lordship.
So refer to your counter affidavit which you have filed.
Your Lordship, if I may,
I read para 9, page 6 of your counter affidavit.
yes, Your Lordship. That with regard to the statements made in pair number 14 of the petition, I say that the department had learned the petitioner's official position, which was temporary appointment under the government, and the extent of questionability of the validity of his officiating appointment order, as stated in pair number 10. Even though such was the case, he was considered to resume duty as officiating electrical worker via order dated 17/7/2019. The order was issued due to the fact that Law and Justice Department had tendered an advice to the department to do the same. The direction regarding counting of the period of absence with effect from 1/6/1992 as dice none is also made in line with the advice of the Law and Justice Department.
So between that is considered as Dines non, isn't it?
Yes, Your Lordship.
Yes. Then read para 18,
And-
para 11,
Pair number 11, Your Lordship.
page 7.
That with regard to statements made in pair number 16 of the writ petition, I say that as can be seen from comments of pair number 2, the department opined that the petitioner was not a government servant governed by CCA rules 1965. Discipline proceedings could not be initiated against him under the rules, and as such, not being a government servant, the petitioner not be placed under suspension or deemed to have been placed under suspension under CSS CCA rules 1965.
Then read,
And
yes, what else? Para 15?
Pair 15, Your Lordship. That with regard to statements made in pair number 23 of the writ petition, I say that Poolal Thanmoy was arrested on 18/5/1992 in criminal charges as per administrative instructions 1A under Fundamental Rules 54B. If the period of his detention exceeded 48 hours and unless he was already under suspension at that time, he is deemed to be under suspension from the date of detention as per administrative instructions 1A below for Fundamental Rule 54B. Further, as per Government of India's Order 432 below Fundamental Rules 54B, full pay and allowances can be paid to the reinstated government servant in case of reinstatement on the ground of dismissal, removal being held by a court of law to have been made without following procedure required under Article 211 of Constitution of India. However, payment of full pay and allowance in such a case is applicable only to government servant not deemed to have been under suspension. Therefore, in view of instructions orders mentioned above, if the government servant was under detention for more than 48 hours in custody, he was deemed to be under suspension. Besides, after his case was settled by the court, he should have joined his post for duties, but he was absent from duties for more than 27 years.
27 years, yes. That you just
There
read,
is-
isn't
yes,
it?
Your Lordship.
Huh. So he cannot claim arrears because he did not join duty. He's absent for so many
Yes,
years,
Your Lordship.
isn't it? I think that's basically your case.
Yes, Your Lordship.
Anything else?
No, Your Lordship.
If, my lord,
Yes.
if I may be allowed to make a small rebuttal, my lord. My lord, my learned friend had, in her cited judgment, it talks about daily wage earner. However, my lord, my case is that if your lordship could kindly come to page number 28, annexure 1
Of what?
of my petition, my lord.
Yes.
Now, I have been given a scale of pay, my lord. This is not uh, a daily remuneration, my lord.
Okay.
And secondly, my lord, the instant petition has not been filed as a matter of right, my lord, as I have already stated, my lord. Since the criminal proceedings was initiated by by my employer, my lord. And third is that, my lord, the reason for not joining my post for 27 years, my lord, this has been explained in the petition as well as in my representation that I have filed before the respondent number 2 and respondent number 5. The reason has been stated clearly, my lord. And that, lastly, my lord, my appointment or my employment has never been questioned by my employer or the state government until filing of the instant affidavit by the state government, my lord. In all the years of my service, my lord, my employment was never disputed.
No, is it disputed? No.
And yes, my lord, if it were really the case that my employment was illegal, my lord, that the
But they're not saying that employment is illegal. That's not their case.
they have disputed that my appointment by an EE, that I cannot be appointed by an EE, that I have to be appointed by
Where's
the.
that in the counter affidavit?
Yes,
That
ma'am.
was not pointed out right now.
But Your Lordship, we have only said that it is highly questionable. However, we have not
Yes.
terminated also on that
Yes.
basis, Your
So-
Lordship.
so
We have
that's-
continued
that's
it.
That's
They-
not an issue,
My lord.
isn't it? Which part of your affidavit did you mention that? Page?
Your Lordship, page number 4 and 5, Your Lordship.
Page number 4 in the last paragraph.
Page number 4, the last paragraph, Your
But
Lordship.
you didn't read that out now?
Your Lordship,
So
I
you're
didn't.
not pressing on this point?
Your Lordship, no, Your Lordship, because we have only stated it is highly questionable. However, based on that, we have not even said that we were terminated.
Okay.
The government is based on the leniency have not even terminated his casual employment, Your Lordship.
So this point has not been pressed because now only after pointing out that you're reading, isn't it?
Yes, Your Lordship, but I had mentioned earlier that he was appointed, but however,
Yes.
it is not relevant to this case because he is still a casual labor, Your Lordship.
Okay. Fine. I just heard Mr. Tira Zekina, learned counsel for the petitioner who has filed the instant petition challenging the order dated 17th July 2019 issued by the respondents, wherein it was held that the petitioner will not be entitled to claim area pay and allowances during his period of absence, but will be entitled from the date of joining duty. The learned counsel submits that the case of the petitioner was that he was initially appointed on master role basis as a lineman in the office of subdivisional officer comma, Lunglei Electrical Maintenance Division, within brackets, now redesignated as Power Maintenance Division, close bracket, since February 1983 till 06/10/1988. Subsequently, he was appointed to the post of Jugali, is it, on officiating basis with a pay scale of in the scale of pay, rupees 750-940 yes, 940, purely on temporary, could be terminated at any time without assigning any reasons thereof. Full stop. The appointment order was made by the executive engineer, comma, Lunglei Electrical Division, comma, Lunglei. And have we mentioned the date? Dated 07/10/1988. Full stop. While he was working on officiating basis as Jugali, he was arrested on 18/05/1992 in connection with Lunglei Police Station case number 123/1992 under section 394/307 IPC, read with section 14 of the Foreigners Act, comma, 1946, full stop. The FIR was filed by the who?
SDO, PNA Department Lunglei, Sri Lalrin Moya.
SDO PNE Department, Lunglei. The petitioner was he in the first case, was he convicted? No.
Yes, my lord.
He was initially convicted under both the sections, under section 394 IPC and section 14
14.
of the Foreigners Act. However, on filing a revision petition, the appellate court, by its order dated 02/06/2011, directed the trial court to consider the case of the petitioner afresh. Full stop. On reconsideration of the case, the petitioner was acquitted from the charges leveled against him on merit by the Court of Judicial Magistrate First Class, Lunglei, vide its order dated 11/10/2013, passed in criminal trial number 102/2017. I think you have made your synopsis too short. You have not mentioned the other cases. Anyways, now just before that, okay, just before the petitioner was acquitted, you had this. Now, in the criminal revision, the appellate court had dismissed the criminal revision against which the petitioner had filed a criminal appeal 2 of 1996, wherein this court, in its judgment dated 31/03/1999, had sent back the case to the learned additional district magistrate within brackets J. by remanding the case for reconsideration or by remanding the case for retrial. Okay. Thereafter, for retrial in form of a criminal appeal. The court of the additional district magistrate within brackets judicial in criminal appeal number 2 of 1996 by its judgment dated 2403, no, by its judgment dated, it's given,
28/6/2000.
wait, it's not given in the heading, it's right behind, dated 28/06/2004, had then acquitted, no, had then, got a long history,
My lord.
convicted the instant petitioner under section 14 of the Foreigners Act. Aggrieved by the said conviction, the petitioner then filed a criminal petition before this court, which was disposed of by its order dated 02/06/2011. By remanding the matter back to the trial court to proceed with the trial of the petitioner on the basis of the charge sheet filed against him. Thereafter, the JMFC Lunglei Judicial District, by its judgment delivered on 11/10/2013, acquitted the petitioner of the charge made against him under section 394 IPC, read with section 14 of the Foreigners Act. On being acquitted by the court, the petitioner had tried to join his duty, which, according to the petitioner, the concerned officer did not allow him to join duty. Thereafter, When was he not allowed to join duty? After he was acquitted?
After he was acquitted, my lord.
Ah.
First was after he had availed bail in the year 1993, and secondly after his acquittal in the year 2013.
Okay. Not allowed to join duty in 2013 after he was acquitted. Full stop. Previously, when he was granted bail, initially, initially he was also not allowed to join duty when he was granted bail in 1993,
January 1993.
January 1993. Thereafter, thereafter, the petitioner had made a representation for allowing the state respondents to join duty. This matter was considered and on the advice of the Law and Judicial Department, in the advice dated 18/06/2019. The petitioner had joined duty. However, he is being aggrieved by the order dated 17/7/2019, wherein he was not allowed his pay area from 01/06/1992 to 16/07/2019. The instant petitioner has filed the writ petition, has approached this court in form of the instant writ petition. The learned Mr. T. Lalizakima, learned counsel for the petitioner, submits that the instant petitioner is not a master role employee, since he was given a scale of pay when he was engaged as Jugali on officiating basis on 07/10/1988. Full stop. He further submits that it was not the fault of the petitioner, since for not joining duty, since he was not allowed to join duty by the concerned officers, and therefore on his acquittal he may be given his pay area. He further submits that the FIR was initiated by his employee and
My lord.
submits that in view of the judgment of the apex court. Yes,
My
isn't
lord,
it?
employer, my lord.
Oh, yes,
Initiated,
employer. Yes, employer. That is, what was he? The
SDO, my lord.
SDO. And thus, in view of the judgment of the apex court in, which was the citation? This one? 2019?
2019.
Yes.
2019.
In Raj Narayan versus Union of India and others, reported in 2019, 5 SCC 809. Para 7, is it?
Paragraph number 6, my lord.
6 and 7.
Paragraph number 6. from
Okay,
the sixth
para-
line.
Para 6, okay? Yeah, in view of para 6, wherein the apex court had held that if the prosecution is launched at the behest of the department and the employee is acquitted, different considerations may arise. The learned counsel submits that in the instant case also, since the prosecution was launched by the FIR, okay, instead of prosecution, FIR was submitted by the employer / department, he needs to be considered considering the fact that the criminal proceeding against him has been in the criminal proceedings against him, he has been acquitted. And therefore, he is entitled to full back wages on his acquittal by the criminal court. Yes. Anything else?
No, my lord.
We have mentioned that you are not a master role, that the FI was initiated, and that you were not
My lord.
allowed to join by the employer himself.
My lord.
Those 3 points.
Yes, and that, my lord, my employment was never disputed.
Yes. No, that anyways,
My
he
lord.
further submits that the petitioner is still employed by the respondents till date, and his employment has not been disputed by the respondents. Yes. Then, Ms. London, learned government advocate, on the other hand, submits that the petitioner was not holding any substantive post, and his employment was only as an officiating capacity, and is actually a casual employee. In terms of his appointment as a jugali, it is clearly stated that he can be terminated at any time without assigning any reason thereof. There is no, even though the petitioner has stated that he was not allowed to join duty by the respondents, there is no such evidence produced showing that he was not allowed to join his duty as claimed by him. As such, he has been absent from his duties for more than 27 years. And he cannot be paid for since he has not performed his duties for more than 27 years. She further submits that the Law and Judicial Department, in their advice, has also clearly stated that the area of full pay and allowances for the period from 10106, okay, 1992 onwards, till his joining duty which is the period of his absence from duty, he is not entitled to be paid any arrears due to his absence from his duty. Anything else?
Your Lordship, Annexure 4, page number 20, the
Page
advice
number
of the Law and Justice Department.
Yes.
Your Lordship, with regards to pan number 1, 2, 3,
Wait,
Your
wait,
Lordship.
wait. Page number 20.
20, pan number 3, Your Lordship. The second para of the point number 1. May I read, Your Lordship?
His claim for regularization. Oh, you had claimed for regularization also, counsel for the petitioner, but I don't think we have to record that.
That
Okay.
is not reflected in my petition, my lord.
Not reflected in your petition, and I don't think you have any stand for that. So I think this para 3 need not be really, since he has not pressed on that point,
Yes, Your
we'll leave it at that.
Okay, yes, Your Lordship.
So basically, your point is that he is not entitled to any full pay arrears
Lordship.
because he has
There's
not
no-
joined,
yes, Your
and
Lordship.
he's a master role.
And there's no statutory
The
basis.
learned government advocate also submits that his initial appointment was also on master role basis. Okay. Under such circumstances, he cannot be considered as a government employee when the government servant in terms of the CCS within brackets, CA rules. That's it.
Yes, Your Lordship.
See, you have filed 2 counter affidavits, but you have not referred to the other counter affidavit dated 09 April 2024. I'm just browsing through that.
Your Lordship, I do not have a copy of that in my
Okay,
file.
that was before your term.
Yes, Your Lordship.
But you have already filed a counter affidavit, so that's why I'm just wondering. And I think your submissions are more or less the same. She further submits that the period of detention of the petitioner has exceeded 48 hours. And therefore, had he been a government servant, he would be deemed under suspension by IA within brackets A within brackets 1 FR 54 within brackets big B. However, since the petitioner is only on employed as master role basis, such procedures as required by the CCS rules is not applicable to him. Thus, she submits that since the petitioner has not performed any duty during the said period, he is not entitled to any back wages. Having heard the submissions made by the learned counsels for both the parties, this court, so and so. Okay, we'll make it a CAB matter. So in the main order, heard Mr. T. Lalzikima, learned counsel for the petitioner, along with Ms. Lal Nuntui, learned government advocate. Hearing is concluded. Matter is reserved for order. Yes.
Duly obliged.
Much obliged, Lordship.